don't you tell us about the Declaration?
Well, the Declaration of Independence was, of course, the seminal document that said to the King George, we are not yours anymore. In other words, it was created and adopted by the Second Continental Congress. It's important to understand that there were, quote, lawyers and lawyer-like people, but certainly very intelligent and educated folks who were at these Continental Congresses. And they realized that you had to not only appeal to the emotions of individuals, but you also had to appeal to the logic and the legal structure that that British citizens had come to respect and understand over time. The Declaration of Independence is therefore structured as a common law legal document which justifies, because of the actions and the violation of what was considered natural law, to separate the colonies from the crown, and based primarily on the tyranny of a ruling king. The fundamental rights of men were validated by the thinkers of the time. The ones you see here are the ones that we hear most about, that all men are created equal, and that the laws of nature and God must be considered in moving forward in the aspects of men. Here's probably two of the big items that tended to separate the folks on our side of the shore from the other ones, and that was you had to have the consent of the government, the governed. The people had to agree. Basically, there was no representation for the colonists in Parliament at that time. So the consent of the governed was not there in terms of living even under a parliamentary monarchy. And here's probably the real key thing that they struggled with now through the Articles of Confederation and then ultimately with the founding of the establishment of the Constitution. The people themselves are capable of governing themselves. This was very much in doubt at that time. Not very many examples had survived of previous attempts at this, and it was considered a very tenuous set of circumstances. But most of you may or may not remember from your high school civics, the Constitution itself was not our first governing document. The first thing we had was the Articles of Confederation, and it's important that you see them as a transition or a bridge. They were proposed in 1777. They were ratified by the colonies in 1781. Remember now, we have a war going on at this time, all right? It did serve as a bridge for a current constitution, but what was the concern about it? Well, it had very strong states' rights. As a matter of fact, it required unanimous consent of Congress and the states to do anything meaningful. And when you think about what that could require, even for 13 colonies or 13 states, a horrendous task, which meant a lot of things were not going to get done. It was a very weak central government, and was designed that way. There were a lot of people at the time who were concerned about whether or not a strong central government might be a problem. And in that setup, there was no executive. Think about it. They didn't have a president. There was no executive actually functioning at that time. The executives you really had were the governors of the several states. You had no judiciary. The courts, to the extent that they were set up in the various states, they were the judiciary. So there was no federal executive, there was no federal judiciary. And clearly, it became apparent early on that there was a need for revision. There are some other things that helped get the Constitutional Convention going and finally led to the adoption of the document. There was, in 1787, a Shays Rebellion. Now, you can notice that by this time we are a country. Okay? We have the 13 states. We are operating under the Articles. There were dead issues with the local militia in Massachusetts. They were to put down with no federal capability. There was no federal way of sorting out this issue in Massachusetts. And pursuant to Madison and Hamilton's request to all states to convene in Philadelphia in 1787, there was a constitutional convention. All states were represented except Rhode Island. Interestingly enough, Rhode Island was concerned at the time that if they went, they would show they were willing to sign on, and they already knew they were a small state, and they were already worried about being cut out. And so they didn't send anybody. Many of the Declaration founders, the ones who were there at the Continental Congress and signed the Declaration of Independence, were there. The intellectual capacity of the folks what constituted our country at that time in that particular convention is actually astounding if you ever check it historically. So the Constitutional Convention is convened. What are the needs, as they saw, to have such a convention? Well, they want to identify and correct the weaknesses of the articles that had demonstrated themselves over the previous years. They wanted to provide for equal and appropriate representation. A lot of concern about that. They wanted to provide for a balanced approach to governing. And as they convened, they wanted to make sure they maintained both civility, because there were a lot of very large type A type folks who were at this convention, okay? And the secrecy, because they were terribly afraid that word would start to leak out and there would be undermining of the grapevine, even though it took a while to get back and forth in at that time. So what were the values they were looking for? We've already iterated what some of the history and tradition of Great Britain's origins were. These were already well embedded in the citizens of the United States. But how are they going to translate this into a new form of self-government and government by those who consent to it? There was a very strong desire for individual liberty and self-government apparent in this convention. Things did not always go smoothly. They met for about 3 months and through some pretty hot weather in Philadelphia, in what we now know as Independence Hall. State representation in Congress was an extremely well-debated item. The House was finally settled on having by population. The Senate equal in a per-state basis, that is, 2 senators from each state. That was the final conclusion after several plans were put forth and debated strongly. One of the considerations for this to keep the balance appropriate was that revenue bills would originate in the House of Representatives only. The power is to be vested in a federal government and a strong executive. These principles were retained and ratified, but the debate led to the ultimate proposal, and we'll discuss them, and ratification of the first 10 amendments as well, the Bill of Rights. How did the document get ratified? Well, the final draft was completed after 3 months. It was signed by all the representatives in September of 1787. Delaware was the first state to ratify on December the 7th. Notice we've got right on it. Okay. New Hampshire ratified as the 9th state in 1788, and that was the minimum required to get ratification. And therefore, at that time, the Constitution became the governing document, the supreme law of the land. Now, I'm going to take a few minutes to give you a brief overview of some of the basic documents, or the basic articles of the Constitution, for those who need a little refresher. In the overview, there's a separation of powers. There's a specific granting of powers. It's a strong but limited national powers respecting the validity of the states. Federalism is a concept which means it's a nation of states. Article 1 talks about legislative. Notice that's the first article that's there. It's defined in the House of Representatives and the Senate. It is topically specific in terms of power: taxation, commerce, currency, establishment of patents, military, and federal courts. These are specifically enumerated powers given to the legislative branch, in this case the House and the Senate. And remember that only revenue bills can originate in the House. They were very specific. And in some cases, it has been traditional for the executive to have these powers. But these were reserved for the legislative branch. And perhaps among the most important ones were the taxation issues and, believe it or not, control of the military. We can talk more about that later. Article 2 is the executive, the president. The quote is to take care that the laws be faithfully executed. He's the chief executive and the chief law enforcement officer of the United States. Basic responsibilities for the executive really are to conduct foreign policy, maintain national security, and provide for the common defense. This is an interesting concept in terms of where we see the president and the presidential powers today. All powers except those to the Congress: coining money, raising and supporting armies, and declaring war. Those are still in the hands of the Congress. Coining money, raising and supporting armies, and declaring war. And isn't it interesting that we have a whole issue before us today as to whether we should be involved in a place like Libya? Is that a proper executive power? And particularly when we have the issue of declaring war. The Congress declares war. On the other hand, no Congress has declared war since December the 8th, I think, 1941. Every military action we've had since that time has never had a declaration of war. On the other hand, is the War Powers Act constitutional? But that's for another discussion. Article 3 is the judiciary, the courts. Now we're going to have federal level courts, which had not been set up before, but it's vested in one Supreme Court and other such inferior courts as the Congress may establish. That is to say, constitutionally, there's the requirement for a Supreme Court. All the other parts of the federal system are set up by Congress thereafter. Judges hold office for life, and the definition of original and appellate jurisdiction is granted. Most of us tend to think of the Supreme Court as having only appellate jurisdiction, but there are enumerated places where the case can first come to the Supreme Court. And there's the major provision for trial by jury. This is important because while trial by jury was something that was generally accepted in the United Kingdom, the British realm, there were lots of places, and for those of you who know anything about the law on the continent, or what's otherwise called civil law, tribunals of judges are the more prominent way that cases are decided, not by juries. Article 4, there specifies citizens' right and new state admission. Specifically, to full faith and credit and privileges and immunities basically means you're a citizen of Georgia, you can go to Pennsylvania, they have to respect the kinds of business transactions and the laws that carry from one place to another. Contracts, business can be done. One state cannot set up, for example, barriers to commerce to the rest, and cannot treat citizens of another state differently from another, and that guaranteed a lot of rights throughout the United States. It also guaranteed a republican form of government to any states that were going to be admitted to the Union. Article 5, amendments to the Constitution. Although it's considered a very fundamental document, it was recognized that amendments might well be necessary over time. So there was a provision for it. If you were to propose an amendment, you have 2/3 of both houses of Congress, which is the traditional way, or by a convention called by 2/3 of the state's legislators. Notice, it's a convention called by 2/3 of the state's legislatures. It's not the state's legislatures. This mechanism has never been used. It's been threatened, but it's never been used, and it may be time. There have been a number of states who wanted to do this. How do you ratify an amendment to the Constitution? It can be ratified by legislatures of 3/4 of the states, or by conventions called in those states for that purpose. That mechanism has also never been used. Article 6. There are various affirmations in this. There's a validation and assumption of previous debts. It basically said that people have to, that the new government under the Constitution would assume the old debts of the articles and so forth. The Constitution and its application are the supreme law of the land. And officials are bound by oath to support the Constitution, but there is no religious test for one to be an official. You have to remember that certainly in those days, most nations had some form of official religion. For Article 7, ratification required by 9 original states, it's basically had to say, hey, we have to have some way to get going. So, I mean, that was the mechanism. Now it's been done. That doesn't really count for much anymore, except you had to have it to get going, so to speak.